Industrial machinery does not forgive human error. When a worker is maimed on the factory floor, the legal claim tests the boundaries of corporate responsibility. Consider this case. Donald operates a factory machine for Plasticware Ltd. To speed up production, he pushed the safety guard aside. His foreman repeatedly told him to replace it, but eventually gave up. Shortly after, Donald's hand was caught, resulting in a severe amputation. Raw facts without a legal framework yield no marks in the exam. We must systematically advise Donald on his rights of claim against his employer. High-scoring legal analysis in employer's liability relies on splitting your argument into two distinct legal tracks. The first track is primary common law liability. Did the employer breach a personal duty owed directly to the employee? The second track is vicarious liability. Should the employer be held strictly liable for a tort committed by another worker? Avoid confounding these two concepts. A primary personal duty is entirely separate from secondary imputed liability. Accurately distinguishing personal fault from imputed fault determines the success of the entire liability claim. This flowchart maps the exact decision tree for establishing an employer's primary liability in tort. The analysis begins by identifying the specific type of harm. Donald suffered a physical injury, which triggers an established duty of care. Before analyzing the common law, we have to address the statutory environment. The workplace is heavily regulated by the Health and Safety at Work, etc. Act 1974. However, Section 47 of that act precludes employees from using breaches of those regulations as the basis for a direct civil claim. The regulations guide the standard of care, but they are not the cause of action. Because the statutory route to damages is blocked, Donald's claim rests entirely on proving a breach of the common law duty of negligence. The scope of the employer's personal duty was defined in the landmark 1937 case, Wilson's and Clyde Coal Co. Ltd. v. English. The issue here is the exact extent of Plasticware's direct obligations to Donald. The rule established in Wilson's, later expanded by Latimer, breaks the employer's duty into 4 requirements: reasonable steps to provide competent staff, provide adequate material, a proper system of work, and a safe workplace. This duty is personal and non-delegable. An employer cannot escape liability by arguing they hired a competent manager to handle safety. Applying this to Donald, Plasticware installed a guard, but they failed to ensure a proper system of work and supervision to guarantee it was used. By allowing Donald to repeatedly bypass the safety fence on the machine, Plasticware breached its primary non-delegable duty of care. A breach regarding competent staff only triggers if the employer knew or ought to have known about the foreman's incompetence. This is the core principle from Hudson v. Ridge Manufacturing. If Donald had suffered from occupational stress instead of a physical amputation, we would apply the Hatton guidelines to determine if the psychiatric injury was reasonably foreseeable. Plasticware's liability attaches because its own mandatory safety system failed on the factory floor. That resolves Track 1. We now evaluate Track 2, secondary or vicarious liability. This flowchart outlines the precise mechanism for imputing one worker's legal fault onto their employer. You must establish 3 elements. The worker was an employee, the employee committed a tort, and the tort was committed in the course of their employment. Prong 1 is straightforward. Under the control tests affirmed in Barclays Bank, the foreman is definitively an employee of Plasticware. Prong 2 is equally clear. Work colleagues owe each other a duty of care. By giving up on safety enforcement, the foreman breached his duty, committing the tort of negligence. The analysis typically hinges on Prong 3. Was the foreman acting in the course of his employment when he let Donald remove the guard? The classic Salmon definition states that an act falls within the course of employment if it is a wrongful act authorized by the employer, or a wrongful and unauthorized mode of carrying out an authorized act. While worker status is rarely the breaking point in exam scenarios, the exact legal boundaries of job execution determine the final outcome. The law must reconcile an employer's specific prohibitions with their general liability for an employee's conduct. In Twine v. Beans Express, a van driver gave a lift to a hitchhiker, explicitly violating his employer's rules. The court ruled the driver was on a frolic of his own, placing the negligent driving outside the scope of employment. Contrast this with Rose v. Plenty. A milkman was expressly prohibited from letting children help on his route. He did it anyway, and a boy was injured by his negligent driving. The Court of Appeal held the dairy liable. The distinguishing factor is business purpose. Giving a lift to a hitchhiker did not further the employer's business, whereas having a boy deliver milk bottles did. Applying this to our foreman, his job was to supervise the factory floor. He was executing his authorized job of supervision, but doing it in a prohibited, negligent manner. This failure is firmly within the course of his employment. Students should not confuse unauthorized modes of work with intentional or criminal torts. Under the Lister principle, refined in Mohamud, employers can be vicariously liable even for intentional violence if there is a sufficiently close connection between the wrongful conduct and the specific duties entrusted to the employee. The common law refuses to let employers extract the profits of labor while disclaiming the negligent execution of the tasks they authorized. We have successfully mapped Donald's claim down both legal tracks. Let's finalize the verdict on the facts. Plasticware is directly liable for breaching its personal, non-delegable duty to provide a safe system of work. They are also vicariously liable for the tort of negligence committed by their foreman in the course of his employment. To complete the analysis, you must anticipate the employer's defenses. The defense of volenti non fit injuria, consent, rarely succeeds in employment cases. Courts recognize that employees face inherent economic pressure to work, which negates the idea that they freely consented to workplace risks. Contributory negligence squarely applies here. Donald deliberately removed the machine guard in violation of safety protocols. This finding will not absolve Plasticware of liability, but the court will use it to significantly reduce the final damages awarded to Donald. Top marks are always awarded for proving the exact legal architecture that links a factory floor injury to a corporate liability, rather than just simply identifying who pays.